for the love of all things holy, please do not enter your criminal defense legal research strategies into your ChatGPT or AI program of choice. Please do not do that. If you know you're under investigation by police or district attorney or attorney general, whatever it may be, the last thing you should do is run to your computer and start figuring out legal strategies on your own by putting inputs or entering queries into your ChatGPT program. This was the subject of a pretty important Southern District of New York federal court case that came down just a couple months ago. It's February, actually. And it concerned a man who was basically being prosecuted for securities fraud. There are going to be some critical points in this court opinion that I'm going to cite, and then I'm going to discuss how, if at all, this will start to affect personal injury litigation, because this is very nascent, this is very new, and as we talked about before with other AI informational videos I've done in this series, this is always evolving, and this is something that will clearly probably still continue to garner a lot of attention as people become more and more dependent on AI for their searches. So the defendant in this criminal case, a gentleman named Mr. Heppner, he found out he was being investigated for securities fraud. And before he talked to any lawyers and before he really had, I think, an idea of what he was facing, he started to build his defense on his own by, naturally, sending things into his ChatGPT, his queries, his inputs. Lo and behold, shortly thereafter, he's arrested or he's indicted. The indictment is unsealed, and obviously the full-fledged prosecution begins. He retains counsel, and during the course of the investigation, naturally, his computers are seized, and that's when his lawyers start jumping up and down, wanting to protect certain searches and work product of his own, that is Mr. Heppner of his own, from being seized and potentially used against him. Mr. Heppner's lawyers and the, I believe it's the Attorney General here for the United States, agreed to segregate certain parts of his searches. They created basically a data file of items that they were going to let the court rule upon to determine if they would be protected by the attorney-client privilege or just be available for use by the prosecution so they could prove their case. So the long and the short of it is this. Nothing Mr. Heppner did on his own without attorney input or guidance was entitled to attorney-client privilege protection. That was the general argument that his lawyers made on his behalf, that these searches that he entered into he used Claude for his AI searches. They argued that, hey, this was something that was protected by attorney-client privilege. Well, the court shot that down pretty much in every respect. But this seems to be the first case where a defendant in a criminal matter is asserting that his searches in AI should be protected by attorney-client privilege. Let's go through some of the notable points that the court made to kind of dismiss all of that. The first point, which the court repeats in its 12-page opinion, is that Mr. Heppner was never told by his lawyers to do what he did. So it's very hard for people to argue that something's protected by attorney-client privilege when, in fact, there was no attorney input into this process. Court seizes upon that and says almost verbatim, like, hey, that's enough to dispose of this entire issue. But it goes through the exercise of addressing the other points that Mr. Heppner's lawyers brought up. Another thing that did not require the court to treat this as attorney-client protected material is that dealing with AI in this instance lacked a trusting human relationship. That's actually a turn of phrase that's in some of the common law and some of the case law that the court cited, which has served as the cornerstone for all privileges that there may be. So while we're focused on attorney-client privilege for the purpose of this video, think of other privileges there might be: doctor-patient, penitent, and priest. Right? There are privileges where, beyond attorney-client relationships, where there's other people involved, and there has to be that trusting human relationship. Well, AI hasn't evolved to the point yet, of course, where it could be considered something equivalent to a trusting human relationship. And then there's something more common sense based that the court cites in its opinion, shooting down Mr. Heppner's argument. The Anthropic policy, and for those who don't know, Claude is the Anthropic AI model. The Anthropic privacy policy, or terms of use, basically permits them to release information regarding queries and inputs and outputs to, guess what, law enforcement and government regulators. And that's exactly what happened here. So the court cites that Mr. Heppner really had no expectation that these inputs and outputs from his queries and his back and forth with his AI would actually be private at all, regardless of how he and his lawyers tried to dress it up in a confidentiality presentation. I love one of the concluding sentences in this part of the opinion. The judge writes in sum and substance that it's textbook law that non-privileged communications are not somehow alchemically changed into privileged ones after being shared with an attorney. And that's exactly what was happening here. Mr. Heppner did all these things without attorney input and guidance, and then try to run behind his attorney to say, hey, this isn't something that we talked about. Shouldn't this fall within the attorney-client privilege? Court had no compunction about basically shooting that down. So how does this kind of fall into, or kind of spill over onto, personal injury cases? Well, clearly criminal investigations are different than a personal injury claim, which is a civil claim or lawsuit. But make no mistake about it, it's obvious that members of the defense bar, funded by insurance companies, of course, seized upon this opinion, because for the first time in my practice, just a couple of weeks ago, on a case that's just starting on the discovery process, I received, as part of a package of initial discovery demands from the defense lawyer here, a specific demand for AI-generated materials. This is the first time that I've ever seen this. But the way that this demand for information and documentation is phrased, it screams that it was kind of pulled from the pages of this Heppner decision that I just spent a few moments talking about. Here's what it asked for. It says, AI-generated materials. Produce all communications, inputs, prompts, queries, instructions, outputs, responses, transcripts, logs, or other interactions between the plaintiff and any artificial intelligence system, generative AI platform, or large language model that relate in any way to the subject matter of this action, including but not limited to descriptions, summaries, or narratives of facts, events, or claims at issue, any request for legal advice, strategy, or analysis concerning the claims, injuries, or defenses in this action, etc. So in plain English, if you think you have a personal injury claim or have a case that comes into fruition, I would tell you, do not start trying to figure out legal strategy on your own by inputting things into your computer. It's probably not going to be protected. Now, the way that this evolves could be something similar to the way that the social media kind of rage, if you will, evolved over the past few years. Once defense lawyers and insurance companies started to make plays for people's social media accounts and unfettered access, and we want to see all the past posts, and we want to see what was deleted, the courts, I think, very rightfully started to limit some of that. Filing a lawsuit, bringing a personal injury lawsuit, does not entitle the whole world to know everything and see everything that you've ever done ever in your life. That's not the way discovery works in a personal injury case, and the courts were quick to modify and adopt the reach that defense lawyers and insurance companies tried to exert in getting their hands on what they considered a treasure trove of information from people's social media accounts. That stuff still happens. They're still making plays for those things, depending, of course, on a case-by-case basis. And I still have to guide my clients and advise them about the pros and cons of living their life online. But the courts have become very reasonable about the parameters and the restrictions and the limitations on the depth and the scope of those types of searches. It'll probably take some time for the courts to catch up with AI here. But remember, the difference between AI and just Google searching things or using any search engine to look for stuff, it's different, right? When you punch in a Google search, no matter how specific it may be, it's going to give you a host of results, right? And links to articles or stories or bios, whatever it is that you might be looking for. AI is actually constructing answers for you. And the technology and the sophistication of AI is continuing to grow, what we're told in the news anyways, day by day, if not hour by hour. People are relying on the information that AI is spitting back to them almost intuitively and in an unquestioning way. Whereas before, when you're doing searches for this or that through a regular search query, you're being pointed, you're being given links to other things. It's not necessarily giving you the answer on a platter like a lot of people perceive and feel that AI does. People are going to start talking to their AIs a lot more too. We've talked about this in the recent past with some of the crazy lawsuits, the wrongful death cases that have taken shape when people start to essentially develop like personal, deep, almost loving relationships with these AI models, especially when they're speaking to them. I know a lot of lawyers, and I see this through listservs and chat groups online. They can't stand that clients or potential clients are looking up for answers for their own cases online. They're using ChatGPT. They're taking screenshots. They're sending it to lawyers. Well, what about this? What about that? Listen, for me, you just have to roll with it. You have to adapt to it. It'd be silly, it'd be naive for me to think that my clients, either current, past, or those to come, aren't going to use AI to help answer some of their own burning questions about their cases and their situations. But I have to caution people now, like the depth and the reach that the other side might have to get to those types of queries on your computer can be really, really problematic. So for example, I've represented a number of people who have had prior injury claims, prior auto accidents, and maybe they're coming to me because they're getting into another accident and things are aggravated or things were made worse. What happens if they start typing into ChatGPT, how will the first accident affect my second? Should I do something different? How can I make it seem like if they start to take steps to explain away or minimize, the first accident from the current one, what could that do? How could that be spun by the other side? Well, I don't know. I mean, my instincts tell me that the other side would try to frame out any searches that people use in ChatGPT or their AI model of preference to, explain away, the obvious, right? Or maybe reflect their state of mind that they know they have a problem with, that they're concerned about something in their past blowing up the here and the now. Look, I don't know. I'm speculating a little bit here, but all I know is that the better part of valor, the prudent thing to do is to at least talk to a lawyer first. Try to get, set down a more comfortable, logical path than just winging it and doing it on your own. If you do those things on your own and it comes to light through like one of these discovery demands that I just read about, and the other side gets very insistent on trying to lock down what those searches were and what those outputs were in response, it could be another variable that just goes into the mix of a case that maybe it doesn't help the way everyone thinks it will. Everyone, again, a lot of people generally seem to just rely on the technology, and I don't blame them. It's becoming more sophisticated and intuitive, but it's hardly perfect. and it's hardly immunized, and you're hardly shielded from everything that life throws at you just because you found some information online. There might be some collateral or some consequences that you didn't think about when you're doing stuff like this. So to sum up this conversation, let's end with what I started with. If you know you're on investigation by the cops or the authorities, don't start talking to ChatGPT about all your legal problems and start to play lawyer by yourself and build a legal defense by relying on what ChatGPT tells you in response. Don't do that, because that could reveal your state of mind as to the problems that you could be facing if you're indeed arrested and prosecuted. With respect to personal injury cases, my initial gut response to seeing this opinion in Heppner and this discovery demand is to tell people just to tap the brakes, talk to your lawyer, get a lawyer. Don't feel as if you have the world at your fingertips just because you have this very sophisticated AI program at your disposal that could actually create more problems than they solve.